of the Supreme Court of the United States. Oyez, 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 all persons having business before the Honorable Supreme Court of the United States are admonished and draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
You may all be seated.
Good afternoon, everyone. I'm Judge Manuela Burrows of the Ohio 8th District Court of Appeals and also co-chair of the Ohio Black Judges Association, affiliate of the National Bar Association. I bring you greetings from our organization. My co-chair is the Honorable Cassandra Paul Williams, who will be serving today as Justice Kagan. I want to welcome you to our second annual Black History Month event. Our first event was last year when we acknowledged that is there in the lobby, acknowledging Judge Perry Jackson, who was the first Black judge of Ohio. This year we will be doing a Re-Enactment of the police example that discusses affirmative action, and you will be able to guess whose ideal this was by who is portraying Judge Ketanji Brown Jackson. So we are very, very thankful for this opportunity to share with you of this very important case, and also to discuss the impact that Judge Ketanji Brown Jackson has had already on the United States Supreme Court. And so who other than to have our own Justice, Melody Stewart, to be the facilitator, and she does parallel many aspects of Justice Ketanji Brown Jackson. They were both former appellate judges. They are the only Black female judges on the bench. And I think that she will bring some insight in terms of what she brings, what insight, and we know the impact that Justice Stewart had on the Ohio Supreme Court, just writing a number of cases of late, the one that deals with bail refund. And you know what happens if the legislature doesn't like what the judiciary does, and they just legislate that away. But in the meantime, she continues to bring insight. She continues to bring a commitment to justice as we continue to move towards the center of justice. And that is the goal of the Ohio Black Judges Association. I would like to acknowledge all judicial officers at this time. If you could please stand and acknowledge your presence, and thank you for your support. All judges, thank you. At this time, I will turn the program over to Chief Justice.
Thank you. Thank you, Judge Groves. Hi, everyone. Hi there. I'm going to give a brief backdrop to today's event. The United States Supreme Court decided the case of Grutter versus Bollinger in 2003. In that decision, a divided court upheld the affirmative action admissions policy of the University of Michigan Law School, ruling that the school could consider race in its admissions process as part of its efforts to assemble a diverse student body. Fast forward to where we are here today, 20 years since Grutter was decided. Currently pending in the United States Supreme Court are two affirmative action cases dealing with race being used for admissions purposes. They were both argued in October of last year. One, Students for Fair Admissions Incorporated versus the University of North Carolina, which you'll see a presentation shortly, and Students for Fair Admissions, Inc. versus the President and Fellows of Harvard College. The cases originated as lawsuits filed against the University of North Carolina and Harvard College by a group called the Students for Fair Admissions, and the group maintains that the University of North Carolina violates the 14th Amendment's Equal Protection Clause, which bars racial discrimination by government entities, by considering race in its admissions process when the university does not need to do so to achieve a diverse student body. The arguments against Harvard College are a bit different. The group argues that Harvard violates Title VI of the Civil Rights Act, which bars entities that receive federal funding from discriminating based on race because Asian American applicants are less likely to be admitted than similarly qualified white, black, and Hispanic applicants. The federal courts in North Carolina, which is the Fourth Circuit, and in Boston, which is the First Circuit, rejected the group's arguments in both cases and upheld the university's admissions policies, prompting the U.S. Supreme Court to take up this case. The cases were consolidated at one point, but the U.S. Supreme Court subsequently severed the two. However, both were heard on the same day, October 31st of last year. The reenactment you'll see today is the University of North Carolina case. In that case, the petitioners, the Students for Fair Admissions, sued the University of North Carolina over its admissions process, again alleging violations of due process clause of the 14th Amendment to the U.S. Constitution because it uses race as a factor in its admissions process. UNC admits it uses race as one of many factors in its admissions process, but argues that the process adheres to the requirement for race-based admissions outlined by this court's decision in Grutter. After an 8-day bench trial and litigation that spanned nearly 7 years, the district court ruled that UNC's admissions policy survived strict scrutiny and was consistent with Grutter versus Bollinger. The student organization appealed, and the United States Court of Appeals for the Fourth Circuit agreed agreed to hold the case in abeyance for the U.S. Supreme Court decision in this case. So arguing today before the U.S. Supreme Court are counsels Marissa Cooper, representing the petitioner, and counsel, you can stand up, Ms. Cooper, please, and counsel representing the respondents' attorneys, former Judge Wanda Jones. Your Supreme Court here, sitting as Chief Justice Roberts, is Judge Charles Patton. Justices Clarence Thomas, played by Judge Ron B. Adrian, retired judge, Cleveland Municipal Court. Justice Samuel Alito by Judge Michael Ryan, recently elected to the Court of Appeals, former juvenile court judge. Justice Kagan is played by Judge Cassandra Collier-Williams of the Common Pleas Court here. Justice Sotomayor is Judge Jasmine Torres-Lugo in the Cleveland Municipal Court. Portraying Justice Neil Gorsuch is Magistrate Jeff Johnson. Justice Brett Kavanaugh by recently elected Judge Jeff Saffold. Justice Amy Coney Barrett is played by Court of Appeals Judge Anita Lastra-Mays, and Justice Ketanji Brown Jackson, played by Judge Lauren Moore of the Cleveland Municipal Court. Thank you for being here, and we'll proceed.
Good morning. The argument first this morning, case 21. Good morning. Learn the technology. We will hear argument first this morning in case 21-707, Students for Fair Admission versus the University of North Carolina. Ms. Strawbridge, oral arguments of Ms. Strawbridge on behalf of the petitioner.
Mr. Chief Justice, and may it please the court, racial classifications are wrong. That principle was enshrined in our law at great cost following the Civil War. A century of resistance to race neutrality followed, but this court's landmark decision in Brown firmly and finally rejected the view that racial classifications have any role to play in providing educational opportunities. Whatever factors the government may use in deciding which jurors to sit, who may marry, or which primary schools our children can attend, skin color is not one of them. Grutter is a glaring exception to this rule. This court should overrule it. First, Grutter is grievously wrong. Its view that the educational benefits of diversity justify racial classifications contradicts the 14th Amendment's guarantee of equal treatment. It relied upon stereotypical assumptions that race is necessarily a proxy for one's viewpoint, and its purported limits are empty and self-contradictory. Grutter also creates many negative effects. Some applicants are incentivized to conceal their race. Others, who were admitted on merit, have their accomplishments diminished by assumptions that their race played a role in their admission. And there is no evidence that after 2 decades, Grutter has somehow reduced the role of race on campus.
Ms. Strawbridge, the respondents argue that if you don't consider race, you won't be able to consider the whole person in the admissions process. How do you respond to that?
Just considering race and race alone is not consistent with the Constitution.
I understand that, but we're talking about an application to a university. If you don't include race, I assume that respondents think that by including race, it tells you something about a person. If you don't include that, then what do you include on the application?
You include their experiences. You include where they grew up. You might include their socioeconomic status. You include all sorts of things that actually lead to broader diversity of viewpoints.
Can we stop a moment? And I want to break down what we're talking about. Sometimes races does correlate to some experiences and not others. If you're Black, you're more likely to be in an undersourced school. You're more likely to be taught by teachers who are not as qualified as others. You're more likely to be viewed as less academic, as having less academic potential.
Well,
Do you want an admissions officer to say, I am not going to look at the race of the child to see if they had all of those socioeconomic barriers present? And despite that they got very high school scores, maybe a little lower or a lot lower SAT scores. But I am going to think, and I am going to think about that. You're asking them to just shunt it aside?
racial classifications have always been disfavored. In a zero-sum game like college admissions, if race is going to be counted, that means that some are going to get in and some people are going to be excluded based on race.
What? Not the logic, facts. What are the facts here about whether or not race is being singularly used to let people in?
Our expert's testimony was that race made a difference in basically 700 applications each admission cycle.
Why is the question race alone? So suppose that there's a 10% plan or something like that, and part of the justification is socioeconomic diversity, and another part of the justification is we'll also get more racial diversity. Is that permissible?
Well, like I said, it's a different analysis when the mechanism that's chosen is not a racial classification itself.
So if you prevail here, let's say, and a university develops 3 race-neutral alternatives to consider in the wake of its decision here, and they choose the one that's going to lead in the highest number of African-American students, and they choose the race-neutral alternative for that reason, is that okay?
There's a burden shifting that occurred there.
What if it's one of the reasons?
Well, I think if they can demonstrate they would have pursued that policy anyway, I think it's sufficient for them to escape liability.
Well, that really means it's not the reason at all. So you are saying if the If that contributes at all to the decision-making, then that's permissible?
No, if the only reason to do it is through the narrow lens of race.
But it isn't that what this plan in UNC already does? Race is never the determining factor. That was a finding by the district court. Race alone doesn't account for why someone's admitted or not admitted. There is always a confluence of reasons. There are any numbers of Hispanics, Blacks, Native Americans who are not chosen by schools. So I'm not sure I understand how you are differentiating your answer.
Well,
If race is only one among many factors, how can you ever prove, given that the district court found against you, that it's ever a determining factor?
well, I don't think there was a finding from the district court.
Well, what it found is you hadn't proved it was.
I think the court went out of its way to not specify in greater detail just how many of those were decisive. But I would suggest that that is a flaw both in the district court's reasoning and in Grutter in general, in that it encourages and basically nullifies strict scrutiny in some ways when you have this many-factor analysis that makes it more difficult to see what effect the racial classifications had.
Can I ask you about that effect? Because I think we really have to drill down on that from a threshold jurisdictional standpoint. I think we have to understand whether race is being used in this context to give rise to an actual, concrete, particularized injury that would give the members of your organization standing to challenge the use of race in this context. I've been struggling to understand how race is actually factoring into the admissions process here, and whether there's an actual redressable injury that arises. So can you help us with that?
Well,
And how are your members actually being harmed by that?
the denial of an opportunity to fairly compete for admission when one of the factors that's used is racial classifications is sufficient to create a concrete injury.
Except Gratz. Gratz was like a set-aside. It was a specific set of circumstances. You could see there that the race factor was creating an unequal playing field because of the way in which the program was structured. Here, I don't really see that happening because no one is, first of all, the university is not requiring anybody to give their race at the beginning. When you give your race, you're not getting any special points. It's about treating just on par with other factors in the system. No one's automatically getting in because race is being used. There's no real work that's it's doing, separate and apart from the other factors in any different way, like it was in Gratz. And when you look at that case, it says specifically, when there's a set-aside kind of program, then we have actual injury, that gives rise to standing. But I'm not sure you have that here.
Grutter establishes that a holistic admissions process doesn't make the injury go away.
But you've said Grutter needs to be overruled. So I don't think we can use that decision as the basis for standing.
One of the problems with Grutter that I think illustrates this specifically is Grutter's suggestion that race can only be used as a plus factor and never a minus factor.
I actually don't think that's the way standing ordinarily works, and I'm worried that you're asking for a special standing rule.
Well,
That you're saying that we can challenge the use of race as a factor without explaining how it's factoring in and how that harms our members. So why is it that race is doing anything different to your members' ability to compete in this environment? That they can still get extra points. They can get points for diversity even in this environment. So why does having race as a factor harm your members in a redressable way?
the record in this case is that UNC gives racial preferences to African Americans, to Hispanic Americans, and to American Indians. It does not give racial preferences to white applicants or to Asian applicants.
Are you sure about that?
Yes.
Because I thought that was not a rule, that anyone could get a point for diversity.
Ms. Strawbridge, can I take you back to Justice Sotomayor's question? She described an applicant who came from an underprivileged school who maybe didn't have the best teaching, best opportunities to score well on the SAT. And I want to know whether, in your view of the world, if a student wrote an essay describing some of the experiences that Justice Sotomayor said, you know, I struggled, socio-economic diversity, racial prejudice, things that shape who I am in your view of the world, could a university take that into account without offending the Equal Protection Clause?
Yes. A member of any race might be put in a position where they feel somewhat isolated or somewhat different.
Okay, so I understood you telling Justice Sotomayor that you thought that you would not be permissible.
No.
I have misunderstood?
What we object to is a consideration of race and race by itself.
Race in a box checking way as opposed to race in an experiential statement?
Which the record in this case is that they can give preference based on the check of a box alone.
Thank you.
What? Where?
Where?
Where? Show me one place the district court found that an applicant checking a box automatically gets a graded point system.
They say that they can take race into account based on that information alone.
But you're making assumptions with that. Can you point into the record where merely checking the box, standing alone as one factor, got somebody in?
Well, of course, there's an email exchange in the record.
That was one person, and not the entire committee.
I think it was a chat between 3 people.
It's a 40-member committee.
May I go back to Justice Baer's question, please? I mean, what are you saying a college can look at, and what are you saying a college can't look at when they're reading an essay about, the experiences that a person has had in their lives?
A story about being subjected to racial discrimination obviously indicates the applicant has grit, that the applicant has overcome some hardship. It tells you something about the character and experience of the applicant other than their skin color.
You keep saying we object to the use of race standing alone. But as I read the record and understand their process, it's never standing alone. That it's in the context of all these other factors. There are 40 factors about all sorts of things that the admissions office is looking at. And you haven't demonstrated or shown one situation in which all they look at is race. And take that from stereotypes and other things. They're looking at the full person with all these characteristics.
Yes, but the use of race as a classification is barred by the Constitution.
Just because somebody checks a box, what if they check the box and the university sees that but doesn't look at it, doesn't take it into account in any way in the application? Do we have a constitutional violation just because the student voluntarily said, I'm an African American, but that never comes into play? What I think you're saying is that people have to mask their identities when they come into contact with the admissions office just on the basis of their difference.
Well,
it never comes into play.
Ms. Strawbridge, let me give you a hypothetical along the lines of some of what you've been questioned about already. Suppose that a student is an immigrant from Africa and moved to a rural area in western North Carolina where the population is overwhelmingly white. And the student in an essay doesn't say, I was subjected to any kind of overt discrimination, but what I did have to deal with huge cultural differences. I had to find a way related to my classmates who came from very different backgrounds. Would that be permissible?
The race is part of the culture, and the culture is part of the race, isn't it? I mean, that's slicing the bologna awfully thin.
When you use race, that is inherently divisive.
But they're offering it because
They're saying that race matters to me. I mean, this is not a situation in which the university is asking or telling every applicant, give us your race so that we can classify people, so that we can give certain people preferences. The only reason why the university knows the race of any of these applicants is because they are voluntarily providing that. Some races get a benefit.
Some races get a benefit, some races do not get a benefit.
Just turning to our precedents. For a moment, distinguish on one hand between racial quotas, which Justice Powell and Bakke said would be impermissible, with pursuing racial diversity and critical mass of different races on campus in Greta, for example. How are we to think about distinguishing between those concepts?
Well, the racial diversity point is interesting because the court's other precedents have rejected racial diversity as a compelling interest in the employment context. It's rejected racial diversity as a relevant factor in K through 12 education.
Your brief, and this is very explicit in your brief, is like, it just doesn't matter if our institutions look like America. These are the pipelines to leadership in our society. It might be military leadership, it might be business leadership, it might be leadership in the law. It might be leadership in all kinds of different areas. Universities are the pipeline to that leadership. Now, if universities are not racially diverse and your rule suggests that it doesn't matter, well, then all of those institutions are not going to be racially diverse either.
Merit and your worth as a person and your value as a contributory citizen is not correlated with skin color. A government that treats people fairly and makes opportunity open to all will necessarily see racial diversity.
I'm just making sure. Look, the college says we're going to give a plus to descendants of slaves. Is that race neutral or not?
I think descendants of slaves is a very difficult question because it's so highly correlated with race.
Could you give a plus to applicants whose parents were immigrants to this country? Is that race neutral?
I think that's probably closer to being okay.
We know that representation for Asian Americans, for example, has grown dramatically over time as their numbers in the population have increased. So have their admissions numbers. But I'm just saying, if we don't have proportionality and no one's seeking that because would be a racial classification, if we have all I see in your models is that we step backwards. We don't step forward.
I think I disagree.
This is a little bit off track, but there's a lot of statistical evidence that suggests that colleges now, when they apply gender-neutral criteria, get many more women than men. Could a university put a thumb on the scales and say, it's important that we ensure that men continue to be or receive college educations at not perfect equality, or, but like roughly in the same ballpark?
That is subject to a somewhat lesser level of scrutiny than racial classifications are.
Like white men get the thumb on the scale, but people who have been kicked in the teeth by our society for centuries do not?
Our position is that white men could not get a thumb on the scale. That sounds like a racial classification. Men, perhaps,
Men could?
but not white men.
Oh, uh-huh.
Well, this court, in the Virginia Military Institute case, said that gender would be an impermissible basis for discriminating against applicants there.
Yes, and it's
And how about religion, for example? There's some evidence, for example, that Harvard adopted its holistic admissions approach in part because it was concerned by the burgeoning number of Jewish persons who were attending, and they were looking for a way to reduce the number of Jewish persons without resorting to a quota.
I mean, that is the history, and I think it's an illustration of why putting something in a holistic admissions policy process doesn't prevent the very invidious effects of race.
Title VI says that no person shall be excluded from participation or be subjected to discrimination under any program or activity that receives federal financial assistance. In Bakke, Justice Stevens argued that whatever the 14th Amendment may allow, Title VI does not permit the use of race. You didn't make much of that point in your briefs, and I just wanted to understand why.
I did not believe it was necessary.
Mrs. Strawbridge, do you agree that universities have a compelling interest in the educational benefit of diversity writ large? Not just racial diversity, but having, different genders, different religious, different viewpoints in the classroom because of the educational benefits of bringing different perspectives to bear on a question?
In this case, we don't think it's an interest that is compelling enough to justify a racial classification.
I guess what I'm concerned about is if it puts a lot of pressure on the essay writing and the holistic review process. Have viewpoint discrimination issues? I would think depending on how admissions officers treat essays. You could have free exercise claims, not by religious mission. Religiously affiliated universities who want to give bumps to say, LDS students, but if you have Harvard saying, well, we want this many Jews, but we also want this many Christians, and this many Muslims in a classroom?
Well, I guess we don't even understand Grutter in part to be suggesting that the interest in this broad benefit of diversity actually justifies kind of micromanaging the populations on campus in a way that you're suggesting.
Thanks.
Mrs. James.
Yeah.
Two questions. Is there any indication from this record that UNC is doing the kind of micromanaging you're talking about with respect to racial classifications? I didn't see that there were shooting for a particular target or that there was a goal. I thought, in fact, that as the reviewers went through the process, they didn't even know how many other students of color had been admitted. And if they did know, they had to be recused.
Well, that policy was instituted after our lawsuit was filed.
So the policy is that they're not reaching towards some sort of goal.
I would not go as far as to say that.
All right. So let me ask you another question, because I take it that your position is that UNC is allowed to consider other non-race-based personal characteristics of individual applicants, like someone's status as a parent or a military veteran or a disabled person, and give pluses in the current holistic environment for those characteristics without running afoul of the 14th Amendment. Is that right?
I think that is generally correct.
And so what I'm worried about is that the rule that you're advocating, that in the context of a holistic review process, a university can take into account and value all of the other background and personal characteristics of other applicants, but they can't value race. What I'm worried about is that that seems to me to have the potential of causing more of an equal protection problem than it's actually solving. And the reason why I get to that possible conclusion is thinking about two applicants who would like to have their family backgrounds credited in this applications process. And I'm hoping to get your reaction to this hypothetical. The first applicant says, I'm from North Carolina. My family has been in this area for generations, since before the Civil War. And I would like you to know that I will be the 5th generation to graduate from the University of North Carolina. I now have that opportunity to do that. And given my family background, it's important to me that I get to attend this university. I want to honor my family's legacy by going to this school. Now, the second applicant says, I'm from North Carolina. My family has been in this area for generations, since before the Civil War. But they were slaves and never had a chance to attend this venerable institution. As an African American, I now have that opportunity. And given my family background, it's important to me to attend this university. I want to honor my family legacy by going to this school. Now, as I understand your no race-conscious admissions rule, these two applicants would have a dramatically different opportunity to tell their family stories and to have them count. The first applicant will be able to have his family background considered and valued by the institution as part of its consideration of whether or not to admit him. But the second one wouldn't be able to because his story is in many ways bound up in his race and with the race of his ancestors. So I want to know, based on how your rule would likely play out in scenarios like that, why excluding consideration of race in a situation in which the person is not saying that his race is something that has impacted him in a negative way, he just wants to have it honored, just like the other person had their personal background family story honored. Why is telling him no not an equal protection violation?
Now, certainly, UNC shouldn't give a legacy benefit if they don't want to give a legacy benefit.
I'm sorry, but you said it was okay if they gave him a legacy benefit. And what I'm saying is that in almost exactly the same set of circumstances, a student or an applicant who is African American and who would like to have the fact that he's been in North Carolina for generations through his family and that they've never had a chance to go to this school honored and considered, and it's bound up with his race, you say, I think, that he's not allowed to say that and that the university is not allowed to take that into account. And because it relates to race, precisely because it relates to race, I think you might have an equal protection problem in saying that he can't get credit for that when someone else can.
If the only difference is between a white student and a black student, I don't think the Equal Protection Clause permits the admissions decision to hinge on that.
Thank you, Faust.
Thank you.
Ms. Park.
Stat.
No clapping in the court. Thank you.
Mr. Chief Justice, and may it please the court. Diversity is our nation's greatest source of strength. But as our Reconstruction founders understood and our nation's history confirms, it also possesses unique challenges to the American experiment. It was Brown's vision that education could be the engine of our democracy, a place where students could prepare for the rights and obligations of citizenship in a diverse and inclusive setting. This learning environment helps us seek truth, build bridges across students of different backgrounds, and critically here, equip students with the tools needed to function effectively as citizens and leaders in our complex and increasingly diverse society. The university retains a powerful interest in preventing the backsliding that would occur if this court took away the power to decide this important social policy issue from the people of North Carolina.
Mr. Park, Ms. Park, I've heard the word diversities quite a few times, and I don't have a clue what it means. Seems to mean everything for everyone. And I'd like you first, you did give some examples in your opening remarks, but I'd like you to give us a specific definition of diversity in the context of the University of North Carolina. And I'd also like you to give us a clear idea of exactly what the educational benefits of diversity at the University of North Carolina would be.
Yes, Your Honor. First, we define diversity the way this court has in this court's precedents, which means a broadly diverse set of criteria that extends to all different backgrounds and perspectives and not solely limited to race. In the last incoming class, 4 out of every 10 students who entered the campus doors were from rural North Carolina. 1 out of every 12 students has a military affiliation, including the most veterans on campus since World War II. And so we value diversity of all different kinds. On educational benefits, SFFA's own expert, and this is on JA 546, conceded and agreed enthusiastically, in fact, on the stand, that a racially diverse and diversity of all kinds leads to a deeper and richer learning environment, leads to more creative thinking and exchange of ideas, and critically, reduced bias between people of different backgrounds and not solely from racial backgrounds.
But you still haven't given me the educational benefits. I didn't go to a racially diverse schools, but there were educational benefits, and I'd like you to tell me expressly when a parent sends a kid to college that they don't necessarily send them there to have fun or feel good or anything like that. They send them there to learn physics or chemistry or whatever they're studying. So tell me what the educational benefits are.
I would like to direct the court to the Major American Businesses brief, which discusses a whole extensive, rigorous, peer-reviewed literature that diverse groups of people actually perform at a higher level. So the most concrete possible scenario is stock trading. And there are studies that find that racially diverse groups of people making trading decisions perform at a higher level, make more efficient trading decisions. And the mechanism there is that it reduces groupthink, and people have longer and more sustained disagreement, and that leads to a more efficient outcome.
Just to follow up on Justice Thomas's questions about diversity again, these holistic admissions approaches seems to stem from the 1920s at Harvard, and they were used as cover for quotas for Jewish persons who the university apparently felt had too many students attending. And I guess I'm struggling still to understand how you distinguish between what this court has said is impermissible, a quota, with what you argue should be permissible going forward, which is diversity. How can you do diversity without taking account of numbers?
I don't think anyone has ever accused the University of North Carolina as having...
I'm not suggesting that.
And we took our cues from this court, from the Bakke decision and from the Grutter decision.
Well,
and
I understand that too, but I guess my question, again, just to get to the core of it rather than circling around, it is how can we do diversity, which that's what you're arguing for, without taking account of numbers?
we do so by looking at the individual applicant. We do not have some sort of racial target.
What is your goal, and how will a court ever be able to determine whether your goal has been reached?
Our goal is to achieve the educational benefits of diversity.
Well, I mean, this is really pretty simple. Suppose you assemble the student body in which the various racial groups coincide almost exactly to the percentage of those racial groups in the general population. Would you say, okay, now we've done it, we've achieved diversity?
No, Your Honor, and I don't think we would say that we need to reach those levels.
All governmental use of race must be a logical endpoint, reasonable duration limits, sunset provisions, and racial conscious admissions policies. And I gather, you know, Justice Alito's saying, when does it end? When is your sunset? When will you know? Because Grutter very clearly says this is so dangerous.
We think that history shows that these programs can and do end. The early programs, as Justice Ginsburg has mentioned, principally end, many of them principally benefited white women. The program in Bakke and the program, federal contractor program, this court upheld in Fully Love explicitly included Asian Americans as among their beneficiaries. And we've reached a point now where we feel that we're able to minimally consider race and still.
The difficulty you're having answering some of these questions about endpoints, and we're probably in the mind of Justice O'Connor when she wrote the opinion in Grutter for the majority. Instead of leaving it vague, the opinion didn't say until you reach a point where you're satisfied that diversity has been achieved, or something vague like that. It said 25 years in there.
We don't read the 25-year as some sort of strict expiration. Even Chief Justice Rehnquist in his dissent said this is not a fixed deadline.
Well, Justice Thomas in his separate opinion referred to it as a holding. Justice Kennedy referred to it as a pronouncement. So anyway, just to make sure the full picture is presented there.
There's no strict benchmark, numerical benchmark.
One of the things the other side has emphasized is that in the, can I ask a question following up on Justice Thomas's too, about what diversity means? Does the University of North Carolina consider one's religion?
We consider it as part of our holistic process, yes.
Could you explain how that works?
And this is helpful because this is the exact same thing that we do for all of our other diversity goals. Is if in context and an assessment of an individual application or applicant, their religious background or their religious experiences suggest that they might contribute something to our campus community, then that can be considered a positive attribute that is considered in our holistic process.
You have them check a box.
We do not have them check a box.
How do you know what the religion the majority of applicants are?
And so we do engage in the same kinds of surveys and qualitative analysis of our campus community.
Is the checking of the box with respect to race voluntary? Is it something that students are required to do or something that they do on their part as part of the process?
It's entirely voluntary, Your Honor.
So you don't know what the race is of all the applicants who are coming into your community from the admission standpoint?
That's correct.
And can you answer a question about UNC's history of exclusion? You mentioned it several times in your brief, and I'd like to understand whether and to what extent that matters with respect to the diversity interests that you are asserting.
We have a unique racial history in our state, and all these programs take society as they find it.
I see. So that might account for why the sort of 25-year expiration deadline can't really be blanketly applied, because we start in different places with respect to how race has been considered to exclude people in our various communities.
Yes, I agree very much with that statement.
Say the difference between the admissions of one group, a racial group A, is 1.2% more than racial group B. Would that be enough for discrimination?
I think it would be enough to state a claim.
So what would you say to, for example, a student whose family came from Afghanistan and doesn't get in because the student doesn't get the plus factor that the student would get if the student's family had come from someplace else? So would you say to the student, well, we don't need you to contribute to a diversity of views at our school because we already have enough Asians. We have a lot of students whose families come from China and other Asian countries. And the student says, well, you don't have anybody like me. I'm from Afghanistan. What similarity does a family background to the person from Afghanistan have with somebody whose family background is in, let's say, Japan?
There was a Vietnamese student. The admissions officer testified about a Vietnamese student who immigrated to a remote part of North Carolina and thrived in that setting. And she testified, undisputed, that was a favorable aspect of her application.
But what is the justification for lumping together students whose families come from China with students whose families come from Afghanistan? What do they have in common?
I agree that that would be a strange rule.
Well, then why do you have them check a box that I'm Asian? What do you learn from the mere checking of the box?
We think that it depends on the individual circumstances of the person.
Why do you have these boxes? Why do you give a student the opportunity to say this one thing about me? I'm Hispanic, I'm African American, I'm Asian. What does that in and of itself tell you?
We think that in the context of everything else that we know about an applicant, it can matter.
So let's say the student has one grandparent who falls within that class. Can the student claim to be a member of an unrepresented minority?
Yes, we rely on self-reporting.
All right, one great-grandparent.
If that person believes that that is an accurate expression of their identity.
One great-great-grandparent. Are you going to make me continue to go on?
I agree that it would seem less plausible.
Well, I identify as an American Indian because I've always been told that some ancestor back in the old days was an American Indian.
So I think in that circumstance, it would be very unlikely that that person was telling the truth.
I'd like to ask you a hypothetical about narrow tailoring, because we're in strict scrutiny land here, and the university has to demonstrate it's narrowly tailored. Race is narrowly tailored, and diversity is the rationale you've asserted before us. Universities also have all kinds of other plus factors they use, like for legacies of alumni, for donors' children, for squash players. We learned that there are plus factors because those, we need those too. And I guess I'm wondering, suppose a wealthy university, could emulate those preferences which tend to favor children of wealthy white parents and achieve diversity without race consciousness. Would strict scrutiny require it to do so?
If I may, I'd like to just make a threshold point that those are not.
I understand, counsel. I understand the hypothetical is not your case and you don't like it. I got it.
Right. But
I've had to face many hypotheticals at the lectern I didn't like.
First, the alternative would have to also match the compelling interest.
We have a great socioeconomic diversity. We'd have great religious diversity. We just would have a crummy squash team and no art museum. And then what?
There wouldn't be a material negative impact on the academic environment.
Our applicants from Middle Eastern countries classified Jordan, Iraq, Iran, Egypt, and the like.
Well, we rely on self-reporting.
But if they honestly check one of the boxes, which one are they supposed to check?
I do not know the answer to that question.
So we've heard a lot about checking the box in the context of the claims that are being made in this case. So first of all, this box is on the Common App, right? It's
Correct.
not on North Carolina's form of any sort. Every student who fills out the Common Application form has the ability.
Correct.
Okay. So everybody who wants to, does North Carolina require anybody to fill out the box that has to do with race?
No.
So there may be some people who don't put anything for race.
There certainly are, yes.
All right. Isn't the question then what North Carolina is doing with that information? Because presumably, just knowing that you have people from different races applying to your school is not working an equal protection violation, is it?
I agree.
So you're not like doing something different with the people who check the box and put in different categories. Everybody then goes into the holistic process of looking at all kinds of other things so that race is never the only criteria that a person is evaluated on with respect to. Is that right?
Absolutely. And we think the district court made findings on this.
And even if you check the box, I'm an African American, I'm a Latino, I'm all these other things, I live in this place, et cetera, et cetera, et cetera. Even if you check that box in North Carolina's system, do you get a point automatically for having checked that box? And is anybody who did check the box, are they automatically entered or admitted into the university as a result?
No.
Given a holistic review process like that, is there a risk of treating people differently by not allowing some applicants to talk about that aspect of their identity? I hear a process in which there's a form that says, tell us about yourself. And people can put all sorts of things. I'm Catholic, I'm from, Los Angeles, I'm Latina, whatever. But now we're entertaining a rule in which some people can say the things they want about who they are and have that valued in the system, but other people are not going to be able to because they won't be able to reveal that they are Latino or African American or whatever. And I'm worried that that creates an inequity in the system with respect to being able to express your identity and, importantly, have it valued by the university when it is considering the goal of bringing in different people. Is that a crazy worry, or is that something I should be thinking about and concerned about?
No, not at all, Your Honor, and it's not crazy at all.
That's Thomas.
You put on extensive evidence about the history of racism in UNC, correct?
Yes, Your Honor. Including a history of its own founding to help the owners, slave owners.
The continuing Confederate rallies, that is 6 on campus.
Yes, Your Honor.
The continuing white supremacy marches, that's still going on.
Yes, Your Honor.
The racial epithets that minority, that underrepresented groups are experiences. To this day?
Yes, Your Honor. If I understand correctly, I do want to clarify one point, is that we are not suggesting, as I understand the university is not either, that the limited consideration of race in this case is being used as a remedial order to address that.
I'm sorry.
But it also, and that in turn impacts their own education within the classroom.
If all the individual incidents and artifacts that you mentioned were not in this case, and if the university were a state university that never practiced segregation, would you say that the case would come out differently?
It may, Your Honor, and that's how and why we should not have an across-the-board policy that all of a sudden jettisons the important limited consideration of race that this court has approved.
Mrs. Park, I may be tone deaf when it comes to all these other things that happens on campus about feeling good and all that sort of thing. I'm really interested in a simple thing. What benefits academically are there to your definition or the diversity that you're asserting specifically? I know kids feel you got studies that show that people feel better and they don't feel isolated, on and on. I'm focusing on what you went to college to do, to learn something. Do you have anything that demonstrates that?
Those would include, for example, fostering innovation, and there's plenty of testimony in this case from chemists, professors at UNC, and from students themselves who have understood the importance of diversity in helping to foster innovation. And this is all the way, harkens back to the Sweet v. Painter case and the McLaurin cases, where they acknowledge that racial interactions and dialogue, between students helps better prepare them for the world that they're going to work and live in.
In light of that, I'm wondering if you have anything to say about affinity groups and affinity housing. That rationale about the educational benefits of diversity presumptively might have some bearing on those questions that are post-admission questions.
Those do invite, very difficult questions, and I think that's how and why a potential colorblind ruling from this court may disrupt things even further, but also about how, certain conditions may apply on a case-by-case basis. Research shows that affinity groups have incredible benefits, not just, for its own members, but in helping the broader community understand, for example, racial and cultural issues, that they might raise.
I understand that Chapel Hill does not have it, but UNC Wilmington does. Would your clients have a position on affinity housing?
I do not know, Your Honor.
Minorities don't automatically get a boost under this system, so it's hard to know whether anyone's being disadvantaged from the mere fact that a minority could get a boost in this environment.
That's right. The evidence showed that hundreds of white students with lower combined GPAs and SAT scores were admitted ahead of higher performing Black students, Latina students who went to UNC. And I think that bears the hallmark of this, the type of individualized consideration that this court wanted.
So in the end, our color blindness, whatever that means, because our society is not colorblind in its effect, that comes as a high cost, not only to UNC and to the state and to the nation as a whole, correct?
That is correct.
So if we overrule Becky, Roeder, and Fisher, the diversity admissions programs across the nation based on those cases will have to be reformulated.
Yes.
In every instance, we are affecting countless existing programs.
Correct.
We are reducing underrepresented minorities.
Yes.
We are depriving others who are not there of the benefits of diversity.
Yes.
And we are doing all of this because race is one factor among many that is never solely determinative, correct?
Yes.
Seems like a lot to ask.
I think we can end there.
Pushed on. Thank you to our panelists. I'm going to kind of stand up and move over here for those who are kind of behind the pillar. We don't have as much time for panel discussion as I would hope, but a couple things, an interesting point to bring up. As you would probably guess, with these cases, there were a lot of amici briefs filed asking the court to accept the petition for cert or not to accept, or how the court should rule. They didn't consider it. In this case and in the Harvard case. And one of the amici briefs filed in support of granting cert in the Harvard case, as a matter of fact, the first amici brief filed in support was by 2 of the 8 members that make up the United States Commission on Civil Rights, but their briefs were filed as individual capacities to the private citizens. One of those members was a local attorney here, Peter Kirsanow of Benish-Friedlander. And urging the court to accept the petition for cert in the Harvard College case and re-examine the court's decision in Grutter versus Bollinger, Attorney Kirsanow and his co-amici concluded that racial preferences neither promote a racial integrated society, nor are they the result of academia's expert judgment. And that's a quote from their brief. They noted that in her majority decision in Grutter, Justice Sandra Day O'Connor wrote that, quote, "The court expects that 25 years from now, the use of racial preferences will no longer be necessary." And they went on to say that that time is almost up and no progress has been made. This case couldn't be a better candidate to begin the process of ending racial preferences. So now, I throw out the first question. So we're at that 25-year point already. And what do you think motivated Justice O'Connor's statement about that? Did she have some crystal ball? Did she really think in 25 years from 2003 when Grutter was decided that there would no longer be the reasons for using racial preferences? And remember, in the UNC's case, UNC's admissions policies are holistic. You heard Attorney Jones say, as Attorney Part, race is one of many factors considered. Do we need racial preferences as a factor at all in admissions process for colleges? Yes, one attorney says why.
Because that are just the very standard still.
Well, we're almost at that 25-year mark. The justice. So should we wait till, what is that? It would be 2028. The other perspective? Yes.
Why did not?
Would you do me a favor and stand up, please?
It's going to be said, thank you.
He said, should we just let the 25 years comment and go? I think, let's look at the numbers now.
Now remember, that's not law. That was dicta, in her opinion, but go ahead. Yeah, I did. Go ahead.
Okay. Because I think if you look at the numbers now, even if you compare our numbers in terms of diversity now with the step we've come back so far. So I think that's why.
I really think it's a situation where hope springs eternal in the human breast. You know, I think that that was an optimistic point of view that Justice O'Connor took. You know, the fact that they had moved off of where they were, and that this was really kind of a radical point of view that they were taking at the point that that decision was made, caused her to believe that other radical, decisions would be made. She didn't anticipate the backsliding that has occurred since that decision was actually announced.
Wishful or hopeful thinking, more so than. Is there the trial court decision in this case is 155 pages, and you trial court judges write opinions that. No. Okay. And another thought too. Were you all disappointed that they didn't have their scripts memorized? Was it just me? You weren't here, I know. Bernie Jones was a big Bernie Jones was a little disappointed. I guess you all are busy in your day jobs.
That's all we had to do.
Right. Peter's the standard.
They're all working full time. So.
I could have just said
That is true. 155 opinion in that case. And as you heard, UNC's admissions policy process is a holistic one. There was one point where Attorney Cooper said that if you have a government that treats people fairly, you don't need policies like this. That's any. I think the big word there is if, right? That's if. But it is a hard call, but with our focus here too on Justice Ketanji Brown Jackson joining the court, she's no wallflower. Could you tell? Great enactment there, and should she be as a junior justice? Should she be?
I don't think so.
I don't.
I'm a junior over at the appellate court. So, and I think that she should have spoken up. What I was concerned about after not just reading this, but going and listening to the oral arguments and listening to some of the other questions that we didn't cover here, is that there appears to be a destruction of stare decisis, and this court will be known for that. We know about the overturning on Roe v. Wade, and now it looks like they're going to overturn Grutter.
Well, and that's an interesting point about that, too, because political pundits, of course, and legal scholars will try to predict the outcome of this case, not only the outcome, but the breakdown, too. Who will decide what? And, will it be based on political appointment affiliation? Remember, for all the lawyers in the room, remember constitutional law class, where your professors would say, so now who do you think will decide this case in what way based on their judicial philosophies? So there will be a lot of discussion about that. And then, with some exception, the Chief Justice will get to appoint who writes the decision. You know, they've got a mechanism there that sometimes, depending on if the Chief Justice is in the minority, he has the senior justice right. Unlike in my court where we write everything, all of our majority opinions we're assigned randomly, believe it or not. Do you all know how we write cases in the Ohio Supreme Court? No. Right? I'll let you in a quick secret. So we hear the cases, and we go in conference, and we speak and discuss the conferences. And we discuss, for those appellate court judges who've sat with us, we discuss the cases by seniority. So the Chief Justice speaks first, nobody interrupts her. She says what she says, and the next senior associate justice, and the next, and the next. Nobody interrupts. And you say what your vote is. And then there's a free-for-all discussion. What were you thinking just voting that way? Are you crazy? And we're a little more polite. And then we discuss it, then it goes around to vote again by reverse seniority. So the least senior justice votes, and it goes all out, and the last vote goes to the Chief Justice. Let's say it's a 4-3 decision, and justices number 1, 3, 5, and 7 are in the majority. We have these high-tech, sophisticated little balls with numbers on them that we put into a leather bottle. The senior justice shakes up that bottle, and senior justice now being Justice Pat Fisher, and sitting next to him is Mike Donnelly. So he turns his head, he puts that hand, opens the bottle. Justice Donnelly turns his head, and then picks number, says, "Lucky number 3." And that's our high-tech way we write majority opinions on the Ohio Supreme Court. But at the U.S. Supreme Court, the Chief Justice does pick. So it will be interesting. I know a lot of you are probably thinking, as Judge Ryan just said, he thinks it's going to be the destruction of affirmative action for use in higher ed. If so, then it'll be interesting to see who writes that majority opinion. And rest assured, I believe there will be other opinions written in that case. All right, I know we've run past the time. We've got some closing, I think I have everything. We have closing remarks by Judge Cassandra Collier-Williams. Get a hand again for our reenactments.
I just want to thank everyone for coming. We do appreciate you coming out to an Ohio Black Judges Association event. We do have some of our members in the audience, and just sort of wave or stand up so that people know that you are members of Ohio Black Judges. We appreciate everyone. And now, regarding the CLE in this case, in this class, it's up for approval, it's pending. Once we will report all the CLEs to the Supreme Court, and the credits will appear on your transcript. In the meantime, if you have any questions, you can direct those questions to ohioblackjudgescle@gmail.com. And again, we appreciate you. Have a great day. Thank you.